वेलकम टू कानून गुरुज। आज हमारे साथ है एडवोकेट रोहित शर्मा, जो कि छत्तीसगढ़ बिलासपुर में प्रैक्टिस करते हैं।
थैंक यू।
थैंक यू सो मच सर। आज आप आए, आपने टाइम स्पेयर किया अपने बिजी शेड्यूल से। सो टुडे वी आर गोइंग टू डिस्कस ऑन लाइक रिट्स, जो कि अपने आप में एक मेन बहुत बड़ा एक टॉपिक है। इस टॉपिक पे डिस्कस करने से पहले मैं जानना चाहूंगी सर, आप अपने बारे में थोड़ा सा बताएं, लाइक आपका जर्नी जो है, लिटिगेशन जर्नी जो रहा है अभी तक का।
Well, I started my litigation career from Mumbai High Court. I was practicing there in handling company litigation, basically winding up petitions and all. Now, in 2016, I shifted back to my hometown in Chhattisgarh, where we have our High Court, which is in Bilaspur. And over here, we handle writ petitions and majorly we handle service matters, civil writs, and also criminal writs. And apart from that, I also handle arbitration matters, certain public interest litigations. And it is, as in a lawyer's journey, we usually expertise in one field, but writ is a mother of all expertise. That is what my understanding is. So let us start with the journey of understanding writs, with what limited understanding I.
That's true. So जो मेरा फर्स्ट क्वेश्चन है सर, हम लोग क्योंकि रिट्स पे ही हम डिस्कस करने जा रहे हैं और आपके जो एक्सपर्टाइज हैं जो रिट्स पे हैं, सो व्हाट इज रिट एंड व्हाट इज द ओरिजिन ऑफ रिट एंड व्हाई इट्स सो इम्पोर्टेंट?
See, when we usually talk of writ, and we usually talk of writs in a very strict sense that it is somewhere prescribed in Article 226 or Article 32 of the Constitution of India. But I would take the permission of yours to travel a little back into the history from where it originated basically and why the writs originated in itself. Usually, we all are aware of the fact that India was dominated by all invasions. It might be Mughal invasions and pursuant to that the Portuguese invasion and also the Islamic invasion. When the Mughals came, they crafted some certain kind of a legal system wherein we are aware of the word of Fauzdari, Devanis and all. Those are Urdu dialectic words. Now, pursuant to that, when the Britishers came, they brought with them a unique system of legal jurisprudence, which we usually called as a English-Saxon system or the colonial system of law. Now, so to understand what they brought to India, we must manifestly understand what was developed there in their parent country or in their hometown. Now, we all are aware or might have heard of the word Magna Carta. Now, what happened in London, in British and UK? There was a fight, a furious fight, which was going on between the power assertion by the churches and the power assertion by the king. In between them, there were the masses, those who are the ultimately the savior. Now, in order to assert certain rights, there was usually certain demands of rights. Now, those demands of rights, which we usually call as the certain basic human rights, which is required to survive as a human, these rights were first of all asserted and given by the king in the manner and the mode of Magna Carta. So the king initially started to seize certain of their rights. Slowly and slowly, when it developed, therein in the king started imparting justice in a formal manner. That was the king's council, king's bench, and the queen's bench. Certainly, later on, we have heard that. But this king's being sovereign, and subsequently, the monarch was replaced by the present system of government functioning. This entire transformation brought one ritualistic folk. That was the writ, that was the prerogative, that was the sovereign sole power to enjoy and to punish or to forgive someone. So this is how the writ developed therein. In India, when the Britishers came, they brought with them their system of law. initially in Calcutta uh, by the Regulating Act of 1771, and so, therein the three Supreme Courts were established in India. Now, one was in Calcutta, another was in Madras, and later on in Mumbai. All these three Supreme Court at that point of time was empowered under the Regulating Act to issue writs. So a writ is nothing but a command of the sovereign. The sovereign says that this has to be done and this is the manner it has to be done and it has to be applied for. So we would be aware of the fact that when this regulating act empowered the Supreme Court, three Supreme Court to issue writs, initially there were two writs which were issued. Now one was the writ of mandamus and the other was the writ of certiorari. Now we'll go into details that what are these and why we have different terminologies for different types of writs. Now, subsequently to that, what happened? This Supreme Courts were abolished, and then the Indian High Courts Act was brought into the foray. This Indian High Court Act also continued the concept of issuance of writ power. Now, this where the three chartered high courts were established by the Indian High Courts Act. This chartered high courts also uses this power to issue certain writs. So now the question comes, since this is a ritual which was followed by the king, that being the sovereign, the energy was vested, the power was vested in the courts. So why there's some kind of power which was usually exercised by a sovereign was vested in the courts, a judiciary as a separate branch? Therein, the concept of Westminster model comes into play, and that is where the division of power comes. There has to be a separation of power, that one power wing does not vest into the another power wing and does not interfere in the functioning. That is the reason that the society has asserted their rights to develop themselves. The right to equality has come into being. This equality concept brought into the foray the cessation of supreme right by the sovereigns. But now, since there has to be someone to look into these things, we have crafted a unique branch of the power vesting authority, which we called as the judiciary. Now, judiciary function as a final arbiter who looks into that whether those powers are exercised rightly or wrongly, then it exercises the writ jurisdiction, that it exercises the writ power to correct, annul, or rectify those errors. So that is how the writ was developed. In India also, in 1950, when we adopted our constitution, there was detailed discussion in the Constituent Assembly, and there was assertions, because while the concept of writ was discussed in the Constituent Assembly, we already had a checkered history wherein we were all aware of that how the writ courts function, how the three chartered high courts have performed their use of the writ power. So we were all aware of. And when the Constituent Assembly set into discussion, it also discussed that how it the Article 32 that was there into has to come into play, and Article 226 how that has to be incorporated and what functions the court has to exercise. Yes.
Okay, sir. So, my next question is types of writs. Like we just, discuss what is writ. So,
Yes.
next point is types of writ. So, there are, so just, explain it in your words.
See, we go by that. What are the types of writs? Now,
Mm-hmm.
means we have initially started our journey or our talk, wherein we have initially held that there's some kind of power which can be issued, and that power is called as the power of writ. Now, before going to that, what are the kinds of writs? What are the types of writs? I'll take your permission to just address on the issue that why writ. Now,
Sure.
this writ, when it has to be issued, when it has to be exercised by some power who is exercising the writ, we come with a precursor to that, and that is the discretion. Now, this is a discretionary power at that point of time of the king whether to issue a writ or not to issue a writ. Identically, today also, those court which exercises the power to issue writ, they are called as a prerogative writ. Now, prerogative writ is something like, though writ is a remedy, but it is the prerogative of the court either to issue it or not to issue it. There might be reasons where, despite having all the conditions where the writ could be issued, the court might abstain from issuing the writ. We'll discuss those things with how it all developed. Now, coming, since this is a prerogative, this is a discretion. So there are five kind of writs which is manifested in the Indian Constitution. Now, Indian Constitution, when we talk of, there are various articles. Apart from Article 32 and 226, I'll also give a brief insight into what are the other articles wherein the writ power has to be considered, because that has to be read in conjunction. Now, the very first writ is the writ of habeas corpus. The second writ is the writ of certiorari. The third writ is the writ of prohibito. Fourth is the writ of quo warranto. And fifth, which is the most usually used, most commonly used, is the writ of mandamus. Now we'll go one by one. Now let us start with the first writ, which was usually used majorly by the then courts, by the courts in the, under the Indian High Courts Act and by the Supreme Court under the Regulating Act, which today also is mostly exercised. Now that writ is the writ of certiorari. Am I audible?
Yes, sir.
Yeah. So this writ of certiorari is a writ when some court, when it exercises the power of issuance of a writ of certiorari, it has to manifestly look into that what are the ingredients required for the issuance of writ of certiorari. So to enable a court to issue a writ of certiorari, there are certain requirements. The very first requirement, that there must be a order, and that order must have been passed by subordinate court or subordinate authority. Number one. Second, when we have an order which has been passed by a subordinate court or a subordinate authority, there must be a manifest error of jurisdiction. That means that the court which has issued that order either has exercised the jurisdiction which is not vested in it, or has issued the writ in excess of the jurisdiction vested. Third, there is one more thing, that this court, while issuing an order, has failed to exercise the jurisdiction. So, manifestly, on the face of record, that order must be arbitrary. This arbitrariness comes from the exercise of a jurisdiction which is not vested in it. And therefore, a natural corollary comes into play, that it would also be hit by concept of natural justice. Now, when the court looks that there is an order which has been exercised, which has been passed by some court in excess of its jurisdiction or in absence of a jurisdiction, then in such a condition, the writ court issues the writ of certiorari and quashes that order. But what we must conceptually, we must keep in our mind that a writ of certiorari is not an exercise and a court of appeal. Usually what happens in CPC or in other criminal law and specific laws, when we have an order in our favor or we are aggrieved by it, someone might challenge it in a court of appeal. But herein, when we challenge it under writ and we seek a writ of certiorari, it is not that we have challenged it in appeal. Here, we challenge it manifestly that it is naturally not tenable because it has violated of its inherent jurisdiction. Now, that is the very first writ. Now, I'll also quote some judgments while we carry forward our journey. Now, that would be a much benefit of the students. Now, the very
Definitely.
first judgment, yes, the very first judgment which we must go through in detail, that when the writ of certiorari must be issued, the Supreme Court has detailedly guidelines, is issued guidelines and is detailed that how this writ of certiorari has to be issued. The judgment is Hari Vishnu Kamath versus Union of India. It is a 1954 judgment wherein the Supreme Court has elaborately defined. So that is something which has to be read into detail. Then Since there is a conflicting view among the legal fraternity that there is a writ of certiorari and there is a writ of prohibito, they both sounds in act and operation much similar. Now we will discuss the second writ, which is the writ of prohibito. Herein, what has to be done and what has to be looked into is there must be an authority. There must be an authority under the constitution which exercises its power. And this authority which exercises its power, it might be a subordinate authorities, all authorities, public authorities, those are established by the purview of the constitutional provisions or by the purview of certain statute. Now, there must be a first, there must be an authority. Number second, the essential ingredient for issuance of writ of prohibito is this authority is exercising jurisdiction or doing something. It means that authority is exercising something. The first, there must be an authority, and second, the authority must be exercising something. Now, when this authority is exercising something, the person who wants to file a writ and want the remedy of writ of prohibito must have the locus in the said exercise. So the concept of locus standi comes into play. Now, this person who wants to file the writ of prohibito, once he knows that there is an authority under the statute and that authority is exercising the jurisdiction, then he would challenge that this authority does not have the jurisdiction to, or the authority is exercising in an arbitrary way, in misunderstanding of jurisdiction, what is not usually allowed him to do. The only difference is between a writ of prohibito and a writ of certiorari is in certiorari also, these are the ingredients, but in writ of certiorari, there must be an order which has to be challenged. But in writ of prohibito, there is no formal order which has been passed. We challenge the authority itself, that the authority is not vested with the jurisdiction or it is exercising in misunderstanding of the jurisdiction. He could not do so. And in such a situation, writ of prohibito was issued prohibiting the authority subordinate concerned from exercising its jurisdiction. So these are the basic differences between the writ of certiorari and writ of prohibito. And while the court evaluates that whether a writ of prohibito must be issued, it keeps in mind that it must be expressly, manifestly arbitrary and with against natural justice. This is how the second writ was issued. Now coming to the third writ, the writ of mandamus. Now this writ of mandamus, we usually when we want any authority to do something, what they are duty bound to do, or to not to do something which they are duty bound not to do, then we can come to the court. We can ask them, ki mandamus in literal sense means to command. Now the writ court, since they are the supreme court, and supreme in the sense that they are constitutionally made supreme as a watchdog of the constitutionality, as a watchdog of the entire genesis of the Indian Constitution itself, entire rights and duties and liabilities of the Indian Constitution itself. In that scenario, a person who is aggrieved can seek the writ of mandamus from the writ courts. Now, this writ court, before issuing a writ of mandamus, would ascertain that what are the essential ingredients for the issuance of writ of mandamus. The very first requirement is there must be a legal right which is vested in a person. A person who wants the mandamus to be issued must have a legal right that this is the right which I want, which I am legally entitled to enjoy. Number second, that the legal right which is enjoyed by some person, there are other persons who are legally bound. They are legally obligated that the person must be allowed to enjoy that legal right. And third, when this person, those who are obligated to allow that person to enjoy that legal right, fails to perform their duty or deliberately does not allow the person to enjoy its legal right, then there is an infringement of some kind of a legal right. In such a situation, the person's grievance comes into play. A person whose legal right has been infringed can, in such a situation, access the writ courts seeking the command to the respective authority for commanding them to work in accordance in tandem with the law. Now, when we talk of the scenario that when mandamus would be issued, now in all these situations, there is one unique thing that has to be considered by any person who files a writ, that there must not be an alternative remedy. Now, why alternative remedy is a bar to issuance of writ, or whether alternative remedy is in really a bar to the issuance of the writ. See, alternative remedy is a remedy wherein some kind of law or some kind of statute prescribe the modalities or the procedure wherein if some kind of grievance has occurred, some kind of infringement of a right has occurred, then in that a situation, a citizen, a person who is entitled to that right or who is injured or whose right has been infringed can access those rights under the specific provision provided under the statute. Like, for example, if a person has been empowered by the RTI Act of 2005 to seek certain informations from the public authorities. Now, once this person go to seek those information, they are denied for one reason or the another. Then there is a remedy that they can prefer an appeal before the respective appellate forum. Even after that, there are much more hierarchical positions. If the first appellate authority does not provide, then you have the provision for the second appeal. Now, what happens sometimes? We believe that this is an infringement of our right which has been provided by the RTI Act, and we directly come to the writ court and ask them to mandate the authority to provide the information. In such a situation, usually when the denial is not ex specie arbitrary, the writ court refrain from issuing writ. They remand it back that go before the appropriate authority, prefer an appropriate application or an appropriate appeal and seek all those informations. Therefore, we have to first ascertain that whether we have an alternative remedy or not. Now, the question comes, supposingly there is a law, there is a statute, and there is an alternative remedy, then would it bar us from seeking writ remedy? Now, the answer is not absolutely yes or absolutely no. Now, in the initial, when I started, I said that these are the prerogative writs, high prerogative writs, and these are the discretionary writs. Not this code. When the writ court exercises its jurisdiction, there are instances when though alternative remedy is available, the court issues the writ and issues on a condition of the test of efficacy. So the test of efficacy comes into play, that what is more efficacious. And when the court is of the view that it is utmost required, it is utmost necessary to ascertain that true justice would be done, and this, the issuance of the writ, is the efficacious remedy, then alternative remedy would be no bar in issuance of the appropriate writ. Now, since we have discussed about the writ of certiorari, writ of mandamus, and writ of prohibito, let us travel further to the writ of quo warranto. Now, the word quo warranto, see, usually a warrant, when we talk of, is in a criminal sense, that someone is asked to be produced before the court, and then we issue a summon or we issue a warrant to be arrest warrant or a bailable warrant. Now, warranting is in a sense that we ask someone, and co-warrantor refers to the authority, that someone is exercising something and we ask them how you are exercising those authority. Now, in literal sense, the writ of co-warrantor is to show your authority. So there must be someone who is exercising those authority. Now, what are those authorities? The very first ingredient for seeking a writ of quo warranto is that there must be a person who is sitting on a public office. Now, what is a public office? Office which is created under any statute or a civil authority or a constitutional post or supposedly a member of the tribunal. There's someone who is sitting and exercising and enjoying that post. Now, this public post Since there is a public post, the very first ingredient is there must be a public post. The very second requirement is there must be a qualification prescribed for this public post. Now, supposingly someone is a member of a parliament, so there are certain requisites which is required to be a member of parliament. Supposingly someone is a minister, there is a requisite that he must be a member of the legislature to be a minister within 6 months. Supposingly someone is a doctor and he has been appointed as a chief medical officer, and then that doctor must have a valid degree to hold that. So anyone who exercises or enjoys a public office must hold a public office, first of all, and second, that public office must be have had a prescribed qualification. Now, when the person who is want to that the writ court must issue the writ of quo warranto, in that a situation, they must have some kind of a notional thought or a process or some kind of evidence wherein they must be of the view or belief that the person so enjoying is not entitled to enjoy for lack of capabilities, and these capabilities are prima facie only one notch, and that is that they lack the requisite qualification, or they lack the requisite age criteria, or they lack some certain kind of abilities for which they are disabled to perform the post, and this particular post they cannot hold for lack of the requisite qualifications. Then what they would do, they would file a writ before the writ court, and they would seek the writ of quo warranty. Now the question comes, in such a situation, can anyone go and challenge it? Like in any other writ, the persons who agree, the one who has the locus standi usually files the writ. But in writ of quo warranto, there is a development wherein the writ of quo warranto can be filed by a person who also is willing to hold that post or is entitled to that post, but someone who is not entitled has been appointed. So someone who has the interest in the locus. Apart from that, since it is a public office, and in India the public offices are for the purpose of a democratic setup for the well good of the public at large. Therefore, a public spirited person can also file a writ of quo warranto under the public interest litigation regime, and the court would issue the appropriate writ of quo warranto. Now, the last but not the least, since we all, those who are viewing, they are all students of and the legal fraternity, we are all able to speak our mind, we are all able to express our belief, we are all able to agree to disagree. This all beliefs, thoughts, faith, expression. We are only able to do so because the constitutional framers have provided us the right to freedom of speech and expression. They have provided us under part 3 of the constitution the fundamental rights. Now these fundamental rights, whenever there would be an infringement to this fundamental right, we can certainly seek remedy by the court. Now the unique question comes, can someone be detained? Yes, they can be. When they are in crossroads with the some kind of a statute or legal permissibility, they would be caught, they would be brought to the court, and they would be kept in jail or behind the bars. But when this detention or this custody is without any authority of law or in crossroad with the law, then such a detention or such a custody of a person so detained is illegal. And in such a illegal detention, such a illegal custody, the person who is illegally detained is entitled to seek a remedy called as the remedy of writ of habeas corpus. Now, the writ of habeas corpus is nothing but to produce the corpus, corpus means body, of the person so detained before the writ court. They would issue an appropriate writ. Now, whether this writ of habeas corpus can only be filed by the person detained? No, it can also be filed by any person who is interested in the person so detained illegally. Accordingly, the writ of habeas corpus would be issued. And there's one more thing. When we talk of writ of habeas corpus, we have to understand that this is a exercise under Article 226, but the writ of habeas corpus is also manifestly ingrained under the three provisions, under the three articles. One is Article 20, 21, and 22 of the Constitution of India. These are also the protective articles which manifestly provide that the Indian Constitution is a unique constitution which not only incorporate right to life and personal liberty, but also incorporates in the constitutional body itself, in the constitutional text itself, that uh, any remedy that would be exercised against state action or against anyone who try to infringe their natural corollary right to life and personal liberty. Now, since we have discussed this, the five kind of rates, and what are those five kind of rates in general sense, because individually, specifically talking of the series of judgments which has been developed before the high courts and before the Supreme Courts. Now, since there's one more question which comes into play, that when these writs are issued by specific courts, now we have two articles in our constitution. One is Article 32 and another is Article 226. Now, Article 32 is the part and parcel within Article 12 to 35, which forms the part of Part 3 of the Constitution, which is the fundamental right. It means, though Article 32 looks like a writ remedy, a discretionary remedy, a high prerogative writ remedy, but in Indian constitutional concept, in Indian legal jurisprudence, this right has been incorporated and ingrained as a unique fundamental right. That means any person, any citizen of India who is whose Article 12 to Article 35 and the various rights enshrined therein, if those fundamental rights are infringed, they can directly knock the doors of the Honorable Apex Court under Article 32 of the Constitution of India. Now, this is a fundamental right which can never be taken away from the respective citizen. Now, while exercising the power under Article 32, the Supreme Court has in many ways have interpreted whether it can be exercised and whether it cannot be exercised. There are certain recent judgments in 2020 and 2021. I'll also briefly elaborate upon them for the viewers. Now, since we are talking of Article 32, we are talking of Article 226. Any writ usually, and especially Article 32, since it's a fundamental right, is issued against whom? So the prima facie question which must arise before in our mind, that okay, fine, that there would be some authority, it would be someone, but what is an authority? What is a subordination? What is this? What is that? So entire genesis, the precursor is Article 12. Article 12 defines state. And what would be state is expressly defined in Article 12. And there are a series of judgment which says that the union, and parliament, the state, the specific legislature, and then in the 93, when the constitution was amended and the local authorities were given the autonomy, now the local authorities in themselves and other authorities of the like nature would be deemed to be state under Article 12, and any state action, if it infringes the right as enshrined under Part 3 for Article 32, is subject to writ jurisdiction, can be challenged before the writ court. Now, whether an authority is a state or not, then there must be a test. The test is the test of adjustum generis clause. The adjustum generis clause of the like nature it means. Now, supposingly we would define that these are the functions of a state, and there is a question before the court that whether this authority is a state or not, then the court would apply the concept of adjustum generis, would do the filter paper test of it, and if it falls within those corners, that authority would be deemingly called as a state, and that state are bound to perform in the four corners of the constitutional mandate as has been provided. Now, there are very important judgment. Now, one is Mohan Lal versus Rajasthan State Electricity Board. Now, in this case, what happened to the Rajasthan State Electricity Board? The question comes that whether the Rajasthan State Electricity Board is a state under Article 12 or not. Honorable Court held that electricity board is a state. Identically, in Sukhdev versus ONGC case, again, whether the ONGC is a state or not, that question was brought before the question, and the court held that it would be state. Now, for the legal fraternity to understand, to analyze that what would be the state, I would quote one judgment. That judgment elaborately provide that what would be state, what would be the essential ingredients of being a state, and what are the requisites to perform as a state, what is a deemingly what would be a state. This is a 1978 judgment, Ramna Shepti versus Airport Authority of India. In this judgment, the Supreme Court has laid down the guidelines that what would be the state. Now, this is a very important judgment. Now, apart from this, when we, in a usual term, when we talk that whether someone is a state or not, what my purview is, what my personal view is that we as a law student must apply another test which we call as a deep and pervasive control theory, right? Now, if supposingly some authority is performing a function and there is a deep and pervasive control of the state authorities, then that would be within the domain of the state definition. Applying that definition, we can always test whether they are bound to perform those functions or not. Now, there is a very, very recent judgment in 2007 or 5 or something, I believe. That's a Z Films case, which we usually called as. There was a case of broadcasting rights. There was a dispute between the Z Telefilms versus the BCCI, which is a broadcasting for cricket in India. Now, the question which arose before the court was whether BCCI is a state or not. Now, this is a unique judgment. Now, this judgment is unique for the reason that when this judgment traveled to the Supreme Court held that BCCI is not a state. But why it held that it would be within the purview of Article 226 for the High Court is the reason that, and this judgment is a 5 judges bench judgment. Since it held that the BCCI performs public function, and we all have some in some ages of our age, in some years of our ages, we have played cricket, and cricket is there in the soul of every Indian, and therefore controlling cricket game, it is in an arena, it is performing a public function. The Supreme Court held that since it performed the public function, and therefore, though they are not state, but are amenable to writ jurisdiction. Now, the unique thing comes over here. The Supreme Court differentiated that they would not be amenable to writ jurisdiction of the Supreme Court, since that would fall within Article 32, but it would fall within Article 226, that is, it would fall within the writ jurisdiction. They are amenable to writ jurisdiction of the respective high courts, because the high courts under Article 226 can exercise writ jurisdiction not only for the infringement of the fundamental right, but for any other reasons also. And this any other reason has been elaborated by the Supreme Court in the Z Telefilms versus BCCI case. Now, when we go that these are the types of raid, there must be a state authority, there must be an Article 12, then there are certain tests which we talked of, as justum generis clause or deep and pervasive control theory. We must also understand that the judges and the high courts and there's all the writ courts, they are exercising some kind of a supervisory power. Now, this supervisory power, this kind of review kind of a power, which we commonly law students we called as a power of judicial review. Now, this review is ingrained and enshrined in another article, that's Article 13 of the Indian Constitution. We have borrowed it from the American jurisprudence, and we have incorporated that. Article 13 empowers the court to do judicial review and to test. There must be a litmus paper test that whether the authority concerned have exercised within the four corners of the law or not. And therefore, in order to understand that how writ would be exercised, what would be writ, and what are the types of writ, the basic requirement for any law student is there must be a sitting attitude and there must be a reading attitude. There must be long hours of reading. And this is developed by the concept of the law of precedent. We will go to the Bayer Act, we'll go to the languages of the constitution, we'll find something written. But what has been elaborated by the respective precedent in some judgments or the another is much more worthy. Therefore, we have to spend long hours sitting and reading. And that is when we will be really able to understand that what is the paradigm shift in understanding the writ and the power of the writ, and when it has to be exercised, when not it has to be exercised. And there's one thing what I would say, since the society is dynamic, it is never stagnant. Identically, law is dynamic. And therefore, since the law is dynamic, some law which is good at some point of juncture of time would not be good today. And therefore, it requires amendment. Identically, the writ power which is exercised by the writ court is also dynamic. It is bound to change and accustom the changing parameters. Yes.
Okay, sir. So my next question is, what is the process of filing a writ in High Court, in Supreme Court? Like, what is the difference? Like, अगर किसी को writ file करना है High Court में, Supreme Court में, तो उसका क्या process follow करना होगा?
See, when we file a writ in the constitution, also it prescribed that the High Court and the Supreme Court are well empowered to frame their own rules and their own procedure. And in a federal structure, since we called ourselves a federal a country which is quasi-federal in nature, the states have their own specific high courts, and we have one federal structure. We have a union, and therein we have the apex court, which is the Supreme Court. The Supreme Court prescribes certain rules, which is the Supreme Court's rules of practice. Identically, every high court prescribes their own rules and procedure. So it would vary from high court to high court. There some high courts might require that it might be in this much number of copies must be served. Like in Supreme Court, we have 1 plus 5 copies to be served, right? So, before filing, and the opposite parties to be served. But what would be the essential ingredient of a writ petition? That we will discuss. Because someone practicing in Mumbai, someone practicing in Rajasthan, someone practicing in Chhattisgarh, anywhere, the respective high courts have prescribed their own high court rules. Now, in those high court rules, what is specifically prescribed has to be followed. But there's something which is very common in all the across the borders. Now, in the writ petition, when we prefer a writ petition, the very first point is there must be a petitioner. Now, who is a petitioner? A petitioner is a person who wants some kind of a remedy by the writ court. It means the person who has some kind of a grievance, who have some kind of a legal right which is not being made available to him, who is entitled to some right, or who some kind of a peaceful right has been infringed. Such kind of a person who prefers a petition before the court is called as a petitioner. So there must be a petition. Number second, this petitioner would be seeking this remedy against some state authorities. Now, these state authorities against whom the remedy is sought are called as respondents. So there must be respondent. The number of petitioners, the number of respondent might vary from the fact of the case. Now, once we have a petitioner, we have a respondent. The third comes into important, that what is the subject matter, what is the cause, or what is the order, or what is the grievance. That has to be specifically spelled out. Once we know all these three things, then we'll come that whether we are coming to file this case, that whether there is already some kind of a case which is pending or not, or in an earlier occasion whether we have also already filed this case, and this is the second round of litigation, that has to be disclosed. Fifth, we have to look into that whether there is an alternative remedy or not. If there is an alternative remedy, why we are preferring the writ, that has to be spelled out. That despite having alternative remedy, we are preferring this writ petition before the Honorable Court for this and this reason. The efficacy is one of the most grundam of. Then we'll also look into, we'll search that whether the caveats has been filed in the subject matter or not. If it is filed, then whether a copy has been served on the respondent authorities or not. That has to be quoted. Then we have to also quote that whether there is any delay. Though In writ courts, the concept of limitation it does not follow, because the writ courts are well empowered, they are high prerogative. Though it is not stricto sensu applied, but still the court would see that whether the person who wants some remedy to be availed, whether he is slipping over his right, because this court would be of no avail to him if without any cause he is slipping over his rights. Then when we have clubbed this kind of information, that yes, we have a subject matter, we have a petitioner, we know who are all the our respondent, there's no delay in filing, there's no alternative remedy, or if there is an alternative remedy, we are well aware of the fact that this is the more efficacious way. And then will come that whether there is a subject matter pending in another high court or in the Supreme Court or in the same high court, or if that has earlier been filed, what was the decision in that and why we want to file it again. Pursuant to this, like I would say, like any one of us, when we try to write a letter, and supposingly if there is a someone who wants to write a letter to his boyfriend or a girlfriend, how it has to be written, that must expressly write it in a manner that it must be read and it must not be thrown. Identically, the writ code, since they are high prerogative writs, they are king. So when we write a letter, we must keep in mind that it must contain everything that we want to say. There must be no overstretching of the facts. There must be no quoting of a word which is just as a misnomer or just out of imagination. Everything must be crystal clearly quoted, and there must be chronological order of quoting every words, so that it becomes easy for a judge to go through our entire records. Now, once we have quoted the entire fact, entire story, then what, as a lawyer, what differentiates a normal draftsman from a lawyer is any person would be able, a literate person, someone who is well capable of understanding and writing, would be able to pen down his story, would be able to pen down his fact. But what differentiates between a lawyer, a petition written by a lawyer, and by any other person is the very next point, which is the ground. The grounds are the soul of your petition. After writing entire fact, a lawyer must well do the research that this fact is causes the infringement of this particular statute or this particular right, or supposingly there is already a judgment or case law on that point, there is an infringement of the honorable court order. Those specific judgment, those specific act, those specific provision, those all must be expressly made clear and quoted in a crystal clear terms in the ground. And in the last, when we club entire from the petitioner to the respondent to all these intricacies to the fact of the case, and then to the grounds and the law which must be like in a normal drafting, we say that the law must not be pleaded, we only need to plead fact. But this is not the case in writ petitions. In writ petitions, we also must plead expressly under the grounds column the law which has to be looked into. Then we come to the last, which is the prayer, which is the relief, and what is the basically why we have filed this writ. Usually, what happens? We put entire thing in the body of the petition, but we fail to ask the remedy. Then, since it's a prerogative rate, it's a discretionary rate, the court might entertain it or might throw it on the instance itself that you have failed to ask for the specific remedy. Therefore, what remedy has to be asked for must be thought, must be before penning down. The basic duty of a lawyer is to reanalyze that what I am seeking. And therefore, it is a saying for the lawyers that whatever, though we pen down 2 pages, but to pen down 2 pages, we have spent midnight lamps oil. We have burned midnight lamps oil. And that is the kind of industrious work which is required to be a lawyer, petition to be drafted. And that is how a writ petition is drafted. Now, the pattern of drafting would slightly differ from one jurisdiction to another. But this is what the basic ingredients of a writ petition is.
Okay, sir. So my next question is, what is PIL, and what is the main difference between RIT and PIL? यानी पीआईएल क्या है एंड पीआईएल और रिट में क्या डिफरेंस है एंड इन दीज डेज व्हाई इट्स सो ट्रेंडिंग.
See, when I would, when we talk of public interest litigation, we in India have seen a checkered history of bloodbath, of invasions, of bonded labor, and everything. We have seen that these authorities, when the Britishers were there was all freedom struggle has happened, and there were round table conferences and various commissions coming into India. Then our leaders at that particular point of time, they were sitting and deliberating for that. These are the rights which is required, and uh, since we have seen that there has been an arbitrary treatment, we have seen that the authorities, those who are empowered to exercise them, have misused their power. So accordingly, by rule of precedence, by since the Supreme Court by Justice Honorable Justice P. N. Bhagwati, as he then was, the concept of public interest litigation was originated. Now, what is in public interest? The entire Indian Constitution is in public interest. The soul of Indian Constitution is public interest, and therefore we talk in our preamble that there must be justice, there must be equality. And the former Chief Justice of India, Justice Patanjali Shastri, he quoted in one of the judgments that, referring to Article 14, that, see, Article 14 talks of two things, that equality before law and equal protection of law. He said that one without the another is nothing. And equality before law could never be achieved without equal protection of law. And equal protection of law will never be there until we have equality before law. And in that sense, a public interest litigation is an extension to the wishes of the constitutional framers. And that has been brought into a formal way by recognition of a concept wherein the person, those who are public spirited. See, the entire Indian constitution, in the entire Indian history, we have seen people, those who are public spirited. The very first jurisprudential work in India in ancient times was done by Akshapad Gautam. Now, he wrote a book which is called as Nyaya Darshan. In that book, he manifested various 16 ways of how the justice has to be done. So the ancient Indian concept also and the modern Indian concept also, as found mentioned in Article 13, we acknowledges custom, rituals, and usages also in not in conflict with the constitution to be the law of the land. So it is the law of the land that public good is our uh, purpose and wish. And that is the concept of a welfare state. When these authorities fail to do so and they high talk and but they do not perform, then the courts have stressed like a Lakshman Rekha, they have crossed the borders and they have exercised this special kind of a power by themselves, and which we usually called as a judicial activism or some kind of those things. But that required a detailed discussion. Later on, we can do that. So this public interest litigation, initially it started with the facet of sufferings of the laborers. Then it traveled into environments. And today, the concept of public interest litigation has expanded so forth that even the non-performance of a public duty, a public spirited person who don't have the locus standi can also come to the court, and the court finds it that it is a genuine litigation and the public good would occur, they do not hesitate from exercising the PIL power. So the basic difference between a writ and a PIL is, in writ, the person who is aggrieved personally, his personal interest has been infringed, he comes into as a petitioner. But in a public interest litigation, for the masses, those who could not approach the court for some reason or the another, or the public spirited person want the society to be good, and he is aware of the fact by his research and everything that this is a case wherein, though I am not personally, my personal right are not infringed, but the entire public and the society would be benefited at large, he comes to the court.
Okay, sir. So my next question is, what is difference between tribunal and court? Because it's very, in these days, like it's very difficult to understand like what is court and what is tribunal for those people who are not connected to court and law, like so that.
See, a tribunal, before going that what is a tribunal and what is a court, what I would like to say that we must understand that what is judiciary in itself.
Definitely.
See, what I started was that there must be separation of power in the various arms of the state. So, what are the arms of the state? The very first arm of the state is the legislature, one who makes the law. Then there is a second arm of the state which we called as the executive, who applies those laws for the benefit of the person or the subject for whom those laws are made. Since the legislature make the law, the executive takes it to the logical end, and to keep a bird's eye, hawk's eye watch over it, that whether the legislature is really making the law for the purpose it is intended, whether the legislature is empowered to make those laws, and second, whether the executive is really performing their duty of what has been the power has been vested upon them, or they are misusing their power. There is a watch which has been kept by a third arm of the state, which is the judiciary. So judiciary means juris. Juris means to do justice. So they want to do justice in entirety by keeping a check and balance. Now what happened? We all are aware of magistrate concept. We have executive magistrate and we have judicial magistrate. A judicial magistrate is a magistrate under the hierarchy of the subordinate judiciary. A executive magistrate is a executive authority, but he is deposed with some kind of power which a magisterial function he can perform. What happens? Though in an ideal state there must be an absolute separation of power, but in practicality it becomes so tiresome that imparting the ultimate benefit becomes impossible. So in that situation, we for small things we have empowered the executive magistrate to perform some certain kind of public order situations and those kind of situations. Identically, what happened when the number of cases, like just for an example, if we take a service matter, we sought an appointment before a public office under Article 16, and there was some kind of an arbitrary exercise by the respondent in conducting the entire public employment, and we are infringed. We filed a writ petition before the writ court because there's no other another area to go for, or we have some certain kind of a dispute on electricity, and we went to the courts. Now the courts are burdened with numerous number of cases. Since the infrastructure of the court is still not fully developed, we have scarcity of resources, and we have much more peculiar typical things to be done, like the criminal trials are there, high property and matters are there, and various declaratory things are there. So now what we brought into concept, that there will be an authority. Now this authority will neither be executive, neither be judicial. There would be a midline path between them. This midline path, we have a concept of quasi nature. It looks like a court, but it is not exactly a court. But since it has been established by a statute, and the Constitution of India provides for establishment of tribunals under specific articles, so this authority which performs the functions of like a court, but is not exactly a court or a judgeship, this authority is called as a tribunal. Now today we have multiple tribunals. Like in some of the states, we have state service appellate tribunals. Then we have electricity tribunal. We have ITAT, income tax appellate tribunal. Then we have GST tribunals. So that we have a different telephone regulatory authority tribunals and all that. Said SEBI appellate tribunal. So accordingly, what happened? The direct uh, burdening of the court has been shredded off, and these tribunals are performing absolutely brilliant function across the frontiers in India, wherever they are being incorporated and made. And this has given us a more hope that yes, our court would be performing only those functions which they are really want to function, and the tribunals can take care of this another quasi judicial purposes. So this is a difference between a tribunal and a court.
Okay, sir. So my last question is about Kanun Gurus. So I want to know your views about Kanun Gurus.
Yeah, before culminating my talk, that I'm very thankful to you people that you allowed me to deliver in this. This is like my first or second talk which I'm doing, and so I believe that such some kind of platform must bring entire legal fraternity into one table, wherein we must have discussions, we must have talks, by which what is not known to me, I'll be learning from you people. What I would be saying might be of some help to you people and to the other viewers. In that shift, what Kanun Guru is doing is a very very wisdomful thing. Apart from that, when I went to your site and when I scrolled it, I was amazed to see that apart from having a frontier of a professional world, you are also culminating with it the KG divine. So a culmination, amalgamation of the spirituality with the professional thing is something which is very unique, which is very ethical, and which must be followed by all other institutions also. That is very very unique. I'm very thankful to you people for allowing me to speak.
Thank you so much, sir. We
Thank you.
are highly obliged to your words and your views. Thank you so much.